Better room, right? Much better than being like squeezed in on the floor and so on. So I wanted to do a couple of things. Like the main thing we have to do today is deal with November 12th. So I'm going to probably wait until the break just because people will trickle in or whatever. We have to decide, and then we'll go with that. So we'll decide that today. Oh, hello. Okay, so I'm just going to wave of people. So today we'll decide the November 12th issue. Okay, and the other thing I wanted to do was pick up on a couple of things from last day, just to tie up a few loose ends, because I felt like the class was a little bit like people were in the corner and some people had their laptops on their laps, you know. So I just wanted to make sure we were clear on a couple of things that we covered during that class, so I'm just going to make sure that they're clear. Okay, so the first thing we're going to make clear is Stewart v. CBC. And remember, we talked about the Stewart case, and this is just a recap. We talked about the Stewart case where Eddie Greenspan was counsel to Stewart, right? And Stewart was in a motor vehicle fatality, and then 10 years later, Greenspan does a show on the CBC called Scales of Justice, right? Remember that? And he talks about the case and so on. And what happens is Stewart doesn't like it. Stewart says, well, hang on, why are you re-enlivening the issue and discussion? It was a horrible time for me and so forth. So he sues Stewart does, and the CBC and Greenspan. And what happens is the court says that, and I'm going to ask you, because I know you may not be well, so lucky you, right? Okay, so I'm going to ask Zoya to highlight what the court's findings are in that case, and then we'll see how it trickles down into the model code. Okay, so the pages are 371, 372, and I'll just show you what I want you to read, assuming your throat holds out, right? There's this paragraph on 371, okay? And then over the page, that little line there. So 371, this section, okay? And then on 372, this next page over, I Okay, so stand up nice and up. So this is what the court determines as a result of Greenspan's conduct in respect of his television episode about Stewart.
I kind of want to read 21 paragraph.
Okay, louder and maybe stand up.
I kind of want to read 21 paragraph 5. It is really stated directly and partially within that one way in which Mr. Greenspan reached the fiduciary duty of loyalty to Mr. Stewart was by putting his own self-promotion or self-advertisement before the interest of the plaintiff. This is an allegation of duty to inform the client which conflicted with self-interest in the form of self-promotion or self-advertisement. Rule 21, paragraph 5 contains two separate directions, not obligations. First, public communication should not be used for the purpose of publicizing the lawyer. Second, a public communication should be free from any suggestion that the lawyer's real purpose is self-promotion or self-advertisement.
Over the page on 372, top of the page.
I find that Mr. Greenspan's turning purpose in involving himself in the production and broadcast in which educational content was otherwise assured was to publicize himself and his services as counsel to a national audience.
Okay, thank you very much. So you see what the court finds is, sure, there was this notional concept of why to reignite interest in the Stewart case, this notional concept of, as Greenspan says, education. I want to educate the public on this important legal issue. But the court says, maybe, but the court finds that the primary purpose, like the underlying real driving force for Greenspan to do the show was self-promotion. Look at what a great lawyer I am. Look at the great outcome I got for my client, and so on. And so that is found to be a breach of his duty of loyalty to the client, and there was some damages awarded. So now, let's see how that trickles down. I need another volunteer. You're good. You're losing your voice. You're good, thank you. So I need another volunteer. Let's highlight what the model code says about that. Volunteer reader, volunteer reader. Delphina. So 7.5-1, commentaries 1 and 3. Nice and loud.
Oh, sorry, I need to.
Okay. Do you want this? You want to get this on? Huh?
Yes.
Okay. That's okay. 7 point, what is it? 5-1, and you want to read that, and then commentaries 1 and 3.
So, provided that there is no infringement of the lawyer's obligations to the client, the profession, the courts, or the administration of justice, a lawyer may communicate information to the media and may make public appearances and statements. All of one or just the highlighted?
Let me see. No, just the highlighted. Commentary 1.
The mere fact that a lawyer's appearance is outside of the courtroom, a tribunal, or the lawyer's office does not excuse conduct that would otherwise be considered improper. Point 3 is public communications about a client's affairs should not be used for the purpose of publicizing the lawyer and should be free from any suggestion that a lawyer's real purpose is self-promotion or self-aggrandizement.
Thank you. Okay, so what we see there is this concept or this notion of, I remember last week we talked about loyalty and all those good things relative to your relationship with your client. What this case says, and what is reflected in the model code, is that notion of, and by the way, 7.5-1 I think is public appearances, like the rule. Relationship to society and other lawyers, and then public appearance, right? So you can speak publicly, you can speak to the media, you can, write an article, you can do such as whatever. Those are all on side with your ethical code. However, in this particular case, the court said, nah, you crossed the line, you went too far, and you talked about self-promotion and self-aggrandizement. Look at what a great lawyer I am, right? So that was the overriding message as found by the court. Okay, so I wanted to make sure that was clear because we touched on it last day, but I don't think we had a chance, I know we didn't, to highlight those sections. The other thing I wanted to pick up from last day was we talked about competency. I remember we were kind of like not sure of the rule, whatever, so just for your reference, it's 3.1-2, commentaries 5 and 6. And competency requires the lawyer to do what? 3 things in order to become competent if they're not competent. And what are those 3 things? What's one? What's one thing? Well, pull up the rule if you like. 3.2-1. 3.1-2. Let's try that. 3.1. Okay. 3.1-2. Okay. Reader. Son. 3.1-2 commentaries 5 and 6.
Commentary 5, the lawyer should not undertake a matter without honestly feeling competent to handle it, or being able to become competent without undue delay, risk, or expense to the client. If the lawyer who proceeds on any other basis is not being honest with the client, this is an ethical consideration and distinct from the standard of care that a tribunal would invoke for purposes of determining negligence. Commentary 6, the lawyer must recognize a task for which the lawyer lacks competence and the disservice that would be done to the client by undertaking that task. If consulted about such a task, the lawyer should A, decline to act, B, obtain the client's instructions to retain, consult, or collaborate with the lawyer who is competent for the task, or obtain the client's consent for the lawyer to become competent without undue delay, risk, or expense to the client.
Okay, undue delay, undue risk, undue expense to the client. Like those are sort of the hallmarks of how you can, and the client's consent, right? Can say, let me have a second chair, give me 6 weeks and I'll get back to you kind of thing, but no prejudice to the client, no cost, additional cost. Okay, so that is cleanup from last class. Today's class is good stuff, right? It's access to justice, pro bono, and the like. Let's start with our fictional lawyer. Who is that? Who is that handsome dog? Julia.
He's the criminal defense lawyer from the film Lincoln Lawyer.
Any ethical issues in the Lincoln Lawyer? And okay, first off, who has seen it? Okay, if you haven't seen it, and you've got no reason, clock. Any ethical issues for old, I've forgotten his name, Haller? Any ethical issues? Those who've seen the movie?
There was something at the end where he charges, I don't remember properly, but then I guess he charges money for without any proceedings, I would say. I don't remember. There was
Okay, that's
something
okay, that's okay. Ikra.
I think he was representing someone and he basically found out like he was a murder, like he committed a murder, his client committed a murder. So he was in a weird spot where in the beginning he started defending him and then over time he kind of found out that he was guilty.
Right. So just as a fictional example, lots of ethical issues in the storyline of this particular fictional lawyer, and that is along the lines of he has a client he's a criminal defense lawyer, and he practices out of the back of the Lincoln car, right? And he practices defense, and he has clients that are like bikers and sort of people. And then he gets a client who is charged with murder, and the client says, I'm innocent. He says, fine, I'll represent you. During the course of the trial, he finds out that not only is the guy a murderer, one of the lawyer's prior clients is in jail for a murder that this guy did. Nightmares. And then a number of other things happen. He breaches a number of. So it's an interesting story. I mean, it's fiction, obviously. It's American, so it's never going to happen that way. But it has all these ethical issues that arise. Like, what do you do? What do you do? Holy crap! One of my clients is in jail, but turns out this guy did. Okay, that's that. And if you haven't seen it, it's reasonably entertaining. And you know what? I included it, so we'll do that later, right? Go to the top, and don't you love that sound? Wakes you up. And here's my disclaimer. And we're talking about access to justice, law and property, legal aid, pro bono work. All good stuff, really good stuff. And there's a general encouragement in the community, in the profession, that applauds work that increases access to justice, and pro bono work, and so on. So that's generally a positive kind of endeavor if you choose to engage in it. And so access to justice has been for many years considered a very serious issue, predominantly because of what? What's the number one issue that causes problems for access to justice? What's the number one issue? Yes, right? Because none of you guys come cheap. Like none of you guys are going to charge $1.50 an hour, right? You're going to be expensive. So that's the first barrier, and it's a constant complaint about lawyers should wear masks because they are robbers. Oh, we forgot our children. Access to justice, that's a serious issue. Abdullah, do you have a joke? Sorry, Muhammad, right?
Yes.
Muhammad, sorry.
I also that.
No, you got to tell me what the right one is.
I would like to share my viewpoint on the same aspect that it's mentioned that the law is also sometimes become difficult in order to get the justice.
You don't want to sit here just because of God was already there.
Sometimes for the uncommon, for the layman, it's difficult to understand the intricacies of the law.
Right?
So sometimes a normal person get into the situation and he doesn't know that he is into the problem.
Yeah. Oh, precisely. A layperson, what the heck, right? Is with court procedure and timelines and deadlines and filings and what does a statement of claim even mean and what is a notice of hearing and so forth. Exactly. So it's another compounding problem in addition to cost, right? People just not knowing that they have legal rights. Okay, good. So this is an article that simply references problems with access to justice from March 2017. And this is a retired Supreme Court justice writing. It's the biggest challenge facing our legal system. Every lawyer I know cares deeply about this and are trying to help. It's a huge issue for these kinds of reasons that we've mentioned, right? For sure, barriers or cost. What's another barrier? Well, we'll get to that because I think there's a section that has an issue with a barrier. Okay, remind me, we'll do the joke later, okay? Because that's part of it. The other, the hand in glove is poverty. People have issues identifying the actual legal issue that's in effect. Referral fatigue in social exclusion. What's referral fatigue in the poverty law world? What's referral fatigue, do you think? What does that suggest? Yeah.
When you're referred from like one lawyer to another, or one social agency to another.
Yeah, I think it's the second, the broader concept. You're referred to social services, and then these are like, people under the poverty line. You're referred to social services, then you're referred to legal aid, and then you're referred to welfare, and then, whatever it's called. Then you're referred to child and family, and so on. So there's that notion of people being pushed down the line, and it gets exhausting. People say, to heck with it. I'm not going to pursue my legal rights. That's an access. That's a barrier to access. Poverty. There's no duty on a lawyer to take on a case with a person who has difficulty paying. That's your decision. And no one's going to say, like, you're not in this for charity. You're in this to make a living. You have to support your family, and so on and so forth. But where you cannot assist someone, and you've seen this notion before, you have a duty to try and find another lawyer without charge. So you say, I'm very sorry, Mr. Smith, I cannot help you for various reasons, but let me give you a name or two of people down the hall or across the street or so forth. And that's when we have that other concept of last lawyer in town, right, starts to collapse in here. And we talked about last lawyer in town is an access to justice companion. Is the legal system part of the problem? Nah. Maybe it is. Lawyers must resist the temptation to take over the case, help the poor. Maybe the system is. Do you have a question? Maybe the system is part of the problem. It's an ongoing debate. Part and parcel is rules of procedure, rules for filings are very complicated, and that's part of the system. I mean, it's a very complex system, and any of you that have practiced in Ontario or elsewhere, I think you'll have seen the complex nature. Even for lawyers, we're constantly saying, hang on, let me just check what that rule says, and double check what the jurisdiction is, or the timeline, and so forth. So you can see where that would be a problem for the lay person or regular person.
Sorry, before you go.
Yeah, sorry, let me go back.
I was a little bit confused.
Is it June?
Yes.
Yeah, go ahead, Bill.
To take over the case, is it to take the case or to take over the case?
You mean here?
Yes. The first one. The
Yeah.
temptation to take over the case.
I mean, I think what that point is addressing is the notion of getting so deeply involved with the person's personal, financial, family situation that you take over their burdens or their problems and take them on yourself. You have to maintain this professionalism.
Distance.
Exactly, the distance. I know that's what's getting there. And you must, so conversely, to engage in that or jump into that pool, you must help the poor to help themselves. In other words, empower people to say, here's what you can do, here are available steps, here are agencies, or what have you. So it's more a question of, the old saying that, you help others to help themselves, as opposed to just taking over
Then I understand.
and sideline. Okay. And remember, we talked about this notion of as you stand in court, as you stand in front of the media, as you write an article and put your name across the bottom, as you tweet something about a case, the rest of us stand behind you, right? The profession stands behind you. But who comes first, the client or the profession? So the point of this sort of theory or thesis is kind of what you said. Not to get so involved with the case that it becomes something you embrace to the point of where you cross over to using clients as a means of promoting cause. Let's say, for example, you feel strongly about the level of poverty in this province. Let's just say you do, and you're just outraged and you're unhappy. And so the notion is, are you taking on a cause at the expense of your client? Really, are you really acting in the best interest of your client to promote their best outcome or their well-being Or are you saying, oh, look at my client, and I'm going to use this as a stepping stone to promote the underlying cause or issue? So the caution here is, that who comes first, profession or the client? And we know the client has to come first in the sense of your duties and obligations and all those good things we talked about last day, loyalty, competence, and integrity, and honesty, and all those good things, as opposed to your own interest, advancing a cause, or using a client's case as a podium. Okay, Kasim, and then.
So, what you just said previously before starting this slide, the previous case that you mentioned, the one in which the lawyer was using the client's case.
Stewart, CBC?
Yeah. So, isn't this the same thing with the applicant?
It's the same notion. Yeah, it's the same concept, right? So, but mind you, as opposed to a cause, the court found that Stewart was, that Greenspan was promoting himself. Like, he was his own cause, right? Whereas this one suggests also it shouldn't be poverty or housing or, whatever the similar concept, you're right.
I feel that the case of Grohe is also very relevant
Okay.
to this concept. The lawyer has the responsibility to maintain the balance. He has to protect the interest of the client, but he also has to take care of the decorum of the court. Because in Zuraya, he has used inappropriate language against other clients, towards the government.
Yeah.
So that's why he was charged from the law society.
Yeah, that's right.
So I feel the responsibility of the lawyer is that he has to strike the balance between the interest of the lawyer and towards the profession.
Right, the profession, the court decorum, using issues as your podium, and so forth. So it's a broad issue, right? It's got many sort of subsets to it, right? So I think that's along the same lines. Okay, access to justice, legal aid. So what's legal aid? Petra louder.
Oh, free legal service.
Free to whom? So how does legal aid work? Does anyone have had a legal aid client? Okay, and so client comes in the door, a legal aid client, how do you know what happens? What's the structure? What's the structure of legal aid? Okay.
You have to know that you have a legal aid certificate.
Okay, exactly, and what's that?
It's like the approval from the government to pay these legal fees.
Right, and who pays the fees?
The government.
And you as a lawyer? Yeah, it's a funded government, except in Ontario, it's been slashed recently, right? Which goes to the access to justice. There's fewer people that have access. Did you have a comment? Yeah, okay. And so what happens is you have like a chart, and issuing a statement of claim, you get paid X dollars, and defense, is that right? You get paid Y dollars, right? So a fixed tariff, a fixed amount you get paid. Too bad if it takes you 20 hours instead of 10. That's the cost of taking on a legal aid client, is you increase access to justice, right? The people who can't afford lawyers now can get funding from the government, but chances are generally, that the tariff amount that you're going to get paid for a particular step in a matter is going to be, shall we say, on the low side. Okay, so it's a fundamental feature of a democracy. Why? Because it increases access to justice for the larger group, because not everyone can afford you guys, right? It's fairness, rule of law, and it has been decreasing over the years, and as I say, recently in this province as well. The eligibility or financial criteria for access have not changed for a long time. So you have to be below a certain threshold to qualify to get legal aid, right? But the threshold is low and hasn't been rising. So even if you make a modest income, if you're not below this threshold, you still wouldn't qualify. And so provision of services for legal aid are complex. legal aid certificates that we've described, public legal education to help people empower themselves to understand, unbundling, I think we'll talk about unbundling a little bit more, but it's just what it sounds like. If there are 10 steps in a proceeding, you can unbundle them and just do 1, 2, or 3, just to increase the access. Duty, what's duty counsel? Anyone do criminal law here?
I guess he is the counsel who is allocated to a person, in
Yes.
case he requires.
Yeah, so if you go down to Old City Hall, way down here, to Old City Hall, and they have like a staircase from the basement up from the holding cells. People come upstairs. I'm the next, person in line to do a criminal matter, and you've got a duty counsel, someone assigned to assist people. They spend 5 minutes, 10 seconds talking, and they have a plea, and they move on. So duty counsel is someone dedicated to assist those without counsel. You can see they're all access to justice approaches. Pro bono, obviously, alternative forms of fees. So, but legal aid, so let's say you want to incorporate a company and you want to have a merger. Are you going to get covered by legal aid? No, not as such, right? So there are some heads or areas of law that are covered by legal aid, and the corporate stuff, not so much. Okay, family law, so you can imagine, family law is one of the largest pools or groups of people with family law issues that need legal aid services. Refugee law, similar kind of concept, right? And so for family law, custody, access, support, child protection, and so on. Refugee law, detention work, specialty cases, and so forth. So those are all areas that will be covered by legal aid. Criminal law offices will provide experienced criminal lawyers, full range of representation. And student legal, so class, right? Downstairs, around the corner kind of. Anyone have any experience with class? And what did you do in the U.S.?
Yes, I
What
was
was
a
it like?
certified legal intern where I represented poor people in court and in legal cases. I worked for Miami Legal Aid.
Okay, exactly. So you had that notion of access to justice for people that otherwise may not have that kind of access to have their rights vetted and enforced, as the case may be. And so students can only do limited things, right? There are limits to what students can attend to do, or interns, I guess. Yeah. Professor Puri, who knows her? So she had a program. Is that still running? Does anyone know? Professor Puri had the program that assisted people with financial issues, like financial investment issues, kind of like a class. But I wonder if she's still running it. I don't know. Does that ring a bell?
It's still.
I need your name tag.
Sorry, I forget my name. The program, I guess, is investor protecting.
Yeah.
Really? It's still.
It's still running. Okay, good. So what do you know about it?
You think that when investors feel cheated or they misconduct in the other side,
Right.
so that they can complain or seek help from this clinic, so
Yeah.
that they will prevent investors from complaining.
Right, exactly. So it's really just another head, right, in addition to criminal and so forth, but it's just through the school. Okay. Also advice lawyers, duty counsel, family information center, education, encouraging people to know their rights. Family law certificates, legal aid certificates will cover only certain areas, right? Custody, access, support payments, property issues, negotiation of investments, and so forth. So I mean, it's not a free-for-all, it's not a hodgepodge, come in, here's some money, go do what you want. There's some very particular restrictions set out. Immigration refugee matters, refugee board hearings, detention reviews, and so forth. Has anyone ever done immigration refugee law? I imagine it's emotionally taxing, I imagine. But then so is family law. Okay, family law lawyers. I don't see any hands. What are you people going to do? Just live on your trust funds from your wealthy parents and get a law degree because it looks good on your cards? Okay, what area of law are we talking about?
Real estate.
Real estate? Trust fund, trust fund, trust fund? Corporate?
I've done a bit of family law, but
Yeah, how did you like that?
no.
Not so much. It's not your favorite. You need a certain constitution, small c constitution to do with that.
Just did one case. I mean,
In what?
actually very good.
Yeah.
Yeah.
Was it just,
We helped a woman who gets monthly support from her husband who left her and the children.
And June, you're next, but come here. Okay. Corporate law, gotcha. No legal aid.
I did family law also in my internship, and you're right, it's very draining, emotionally draining. I wanted to help people, but it just
It took too much, yeah.
too much.
Yeah, that and criminal law, right? No criminal law lawyers. Okay, also takes a certain constitution, small c constitution. What did we do this one? Civil cases. Okay, some civil cases and appeals, workplace safety, social benefits, employment insurance, mental health hearings and appeals. So you can see these are the kinds of client communities or groups that specifically may need this kind of assistance, right? And the criminal charges, other rules, result that have to be jail time kind of things, bodily harm, robbery, and so on. Okay, and so those are the limits and restrictions on what can and cannot be covered by legal aid. Okay, so BC, out in BC, there's a lawyer called Mr. Christie. And back in 2007, 12 years ago now, 12 years? Yeah, 12 years ago now, he was practicing poverty law, right? So he is among the group of people that are assisting those, right, who live below a certain level of income. And he earns a limited income from his practice. So he's not in it for the money, right? He's in it for, he believes, the greater good or a cause that he believes in, and he's not concerned about a yacht or a Porsche. He's concerned about helping people that actually need representation and need the skills that he went to law school for. So Mr. Christie runs a practice. And what happens is the BC government imposes a 7% tax on legal services. And he says, hang on, I'm doing the good work here. I don't earn very much by virtue of the nature of the work. And now you're going to tax me an additional 7%. And he says there's a constitutional right to legal services, which is an access to justice issue, right? Makes sense. And he argues, I shouldn't be taxed on that. I shouldn't be burdened. I should be encouraged to do that, right? That's what he says. But the court found if we did that, and this is kind of a policy, political, kind of a gray area decision, the court finds that if we say, yes, you're right, Mr. Christie, if we say you're right, that would mean expanding legal aid to everyone and everything, and that would be too expensive. So it's a kind of a cost-benefit analysis, right? The court finds no general fundamental right to access to legal services, and that the charter only refers to a specific instance of a right to counsel. So what the court does in that case is a little bit of reading down, right? They say, well, because of this policy issue about it would be too expensive and lots of funding, we read it to say, nah, it's not a broad, it's very specific per individual or per client. So too bad for you, Mr. Christie. Post-Christie, the Supreme Court of Canada, this is some years later, right? So 7 years later, we have the Trial Lawyers Association, again in BC, with 7 interveners. And we talked about interveners, right? And interveners are? Whoa, I got it. Jean, you're first. Not a party, right? Anything else? That's it. Not a party, but have an interest and are allowed to make submissions to advocate whatever their position is, even though they have no stake in the outcome of the individual parties. And in this case, the family law custody dispute was over getting a trial date. There has to be a court fee to get a trial date, and the client says, well, can you just waive that fee because there's another barrier to access to justice. I can't even get a court date until I pay the administration fee, right? And the person wants to be relieved from the fee, is a self-represented, and the fee would be this total for this many days of hearing, and it's almost the net monthly income of the whole family. So either you can, pay the fee and go to court and take your chances, or you can feed your family and pay the rent. The trial judge held the fee was unconstitutional. The Court of Appeal agrees. Appealed to the Supreme Court. The province cross appeals, and what happens is the decision 5-2 split to say hearing fees are unconstitutional. Right? Too much of a barrier to access to justice, and the Supreme Court says access is fundamental to the rule of law, and if people cannot challenge court actions, they cannot hold the state to account. And the balance between the state's power to make and enforce laws and the court's responsibility to rule on citizen challenges to them may be skewed. And they referenced the Christie case 7 years earlier. You know how the Supreme Court is, right? They have a bunch of cases, they know what's coming up, and they know what's in the past, and sometimes they're building on existing case law, right? So you get things like trilogies, you get things like evolution of law, and different cases that they take up on a particular issue and evolve the legal concepts. The Supreme Court said the decision in Christie does not undermine the proposition that access to the courts is fundamental to our constitutional arrangements. The Supreme Court says the Christie case does not limit us from making a finding in this case, because we're going to evolve the notion of the law. So in the 2014 case, the hearing fee required the potential to bar litigants with legitimate claims from the courts. Access to justice, right? Legal aid problems, underfunded, not available throughout the country because it's a provincial program. So Ontario is different than BC, maybe different than Alberta, maybe different than Newfoundland. And eligibility requirements in Ontario are too low, only covers limited areas.
Are the breakdown in the amounts, is that different in different provinces, or is it the same?
I think it's different. Don't quote me. You can look it up, but I think it's different. So the focus for our course is Ontario, which the arguments are ridiculously low. We'll find a case that talks about that. But it's provincial, so it can be different in every province. So I don't know the answer to it, but I think they're different. Okay. Well, how do we improve this system? Like, how do we improve legal aid? So some of the theoretical concepts of how to improve this arguably underfunded, skewed system are recognize it as an essential public service. Focus on the most need, which are these two areas. I guess the largest pool, family law and poverty law. Modernize the eligibility requirements, which are the thresholds, right, for income. More policy development. So, I mean, all of these things are nice, and you hear politicians talking about them, and people write articles and so on. But these are theories and ideas and theses that are being put forth as to how to address this constant chronic problem. The legal aid eligibility requirement was last reviewed in 1996. 23 years ago. And it found that low to middle income Canadians have legal issues they just can't afford to resolve. They just have no access to justice in that sense. Typically around family, employment, creditor, and so on. Increasing numbers of self-represented people because they can't afford lawyers, but a self-rep, first of all, it's your nightmare when you have it on the other side of you to work with. However, for that individual, that's their only option, right? They don't have access to legal counsel. And former Chief Justice McLaughlin considered it a crisis, and she's not the only one. So what are some of the other approaches to this issue and problem? CBA, Canadian Bar Association, is a voluntary organization. You can join if you like. By all means, go ahead. And they have a platform on legal aid reform, such as essential public service, national standards as opposed to provincial standards, and the federal government should revitalize its commitment. The federal government. R.V. Moody, 2016. So here's a case. Do I have a page? I might have a page reference. A page reference? Yes or no?
707.
Pardon?
707.
707. Let's see. 707. 707, okay. So the Moody case is a 2016 case of Justice Nordheimer, smart guy. I think he's gone to Court of Appeal now. Smart guy, doesn't mince words in his judgment. He's not, doesn't obfuscate. And so in R.V. Moody, we have an individual who is seeking legal aid and is denied. So can we get a reader to tell us what R.V. Moody is all about? Reader and volunteer. Volunteer reader, thanks. So page 708, this last full paragraph.
The Crown submitted that the applicant had failed to take adequate steps to try and find other sources of funds to pay defense counsel. Obtaining a bank loan, having a family member co-sign for a loan, getting a second job, borrowing against credit cards, and other suggestions were made. None of those suggestions are, in my view, realistic ones. No financial institution is going to loan the applicant money given his income level, his lack of exigible assets, and his outstanding credit card debt. The applicant's father has made it clear that he is not going to assist his son in any way. Unfortunately, the applicant's mother is no better suited financially than is the applicant. In terms of co-signing for a loan, the applicant has looked for a second job, but he has been unable to find one, at least in part because of his bail conditions that include a curfew. There is no realistic prospect that the applicant could borrow any further amounts against his credit cards, certainly not the amounts necessary to fund the retainer. The costs of the trial were estimated by counsel for the applicant using the lowest hourly rate permitted by Legal Aid Ontario at more than $11,000. The applicant has asked family members for monies to fund counsel, but save for $500 he received from the godmother, nothing has been forthcoming.
Okay, thank you. So what Justice Nordheimer is saying in this decision is that, like, you're not being realistic, right? The guy's 23 years old, and he's charged with, like, serious stuff. Presumption of innocence. He's charged with serious stuff, right? Cocaine, trafficking, marijuana, well, property by virtue of possession. Right? Yeah. He'd be a different vote today. Possession of property obtained by crime. He has no record. Here's his income, and that's gross. So net, he's netting out, less. Yeah, he's netting out less, and he lives at home with his mother, and he gives her money to, assist her with them, and so on. And the father says, I don't care. I'm not going to. So what Justice Nordheimer says is, so he's denied legal aid. This guy, in the R.V. Moody, so he's charged criminally, right? Justice Nordheimer says, not realistic given the realities of the dollars and cents that we're talking about, the family members, credit cards, and loans, and all that kind of nonsense. So that's page 707 and 708. And I have a page reference for you that, for Christie, I'll just give you the page reference for Christie. Christie is page 701. 701 is the Christie case, Supreme Court of Canada, and yes, you can read that case, and this is Moody, right? Okay, so Moody. So Justice Nordheimer says, in Moody, it's obvious to any outside observer the income threshold being used by Legal Aid Ontario not bear any reasonable relationship to what constitutes poverty in this country. It does not make words. And he says, Stats Canada says the cutoff level for persons living in a city are 24,000, which is more than twice the figure Legal Aid Ontario uses. So in order to qualify for legal aid in Ontario, you have to earn less than the lowest income available in the province, like statistically speaking, right? So they're not hard figures, but they're stats. Anyone below the low income cutoff will have their income consumed by food, rent, and will not have sufficient income for extraordinary expenses, such as a criminal defense lawyer. And he says in his decision, it is necessary for the applicant to have counsel in order to have a fair trial. The charges are serious, the potential penalties are serious, and he has satisfied me, the applicant would be Moody, that he does not have access on a reasonable basis to any other source of funds to retain counsel. An example, a case where access to justice has been discussed and considered in Ontario. Yeah.
So would you say if someone is facing incarceration, criminal penalties, that the court would allow them to get funds from the prisons?
So we know that serious crimes that include jail time, for example, we know that those are covered by legal aid. But what happened in the Moody case is, in order to have coverage for legal aid, the allegation of the crime or the charge meets the requirement for legal aid, but his income level was considered.
Yeah, so that's what I mean. Other people in general.
Yeah, so you would rely on this, if you're in a situation where a client said, well, I want to earn $20,000 and that's too high for legal aid, you might rely on this case to say that's not a realistic threshold. Try to convince the legal aid people. I don't know what kind of discretion they have.
Yeah, that's what
I don't know. Okay, another way to address or approach the problem with access to justice is duty counsel, right? They advise people, we talked about that, on the rights in the court process. Paralegals, only in Ontario, are regulated, and paralegals will provide services at a lower rate, right? Another way, limited retainer unbundling. The notion that a lawyer might provide services limited to a specific task on a file without being counsel of record. Model Code 3.2-1A will speak to that. Do you foresee any problem or any issue or concern with unbundling? There are 10 steps in the process. I'll help you with step 1 and get you going, but the other steps, we'll have to figure out separately. Any problems with that approach that anyone can think of? Of unbundling, breaking it down into the various components or steps?
maybe the services might become disconnected.
Yes, that's one problem. Anyone else? Well, how straightforward is a litigation? Sometimes, but normally, or at least one of the criticisms, is the complexity of almost all files, make it a challenge to provide competent, effective, and continuous, consistent representation and advice. Because you don't know what 2 steps ago someone else did. Nadia.
Isn't it a bit of a learning curve too, which could also make it more expensive in a roundabout way? Like it takes longer for people to learn what the previous party did, and although the client might not be taking that on if they don't qualify for legal aid or unbundling or whatever situation, it's the cost being carried over to the next person.
Sure. Could you say, oh, here, bring a motion for summary judgment. Well, what's the case all about kind of thing, right? So there's that built-in learning or catch-up speed. Yeah, I think that's right. Limited scope retainer. What's a limited scope retainer? What's a limited scope retainer? Limited scope retainer. So what's a retainer? What's a retainer?
It's a contract for legal service.
Yeah, so it's a K for contract, right? What else is it? We also talked about this. What else is a retainer?
Talks about the fee services.
Well, one at a time. I need to call your names. Hasrat.
One, it talks about the fee that the client is going to pay the lawyer. Number 2, it also talks about the agreement the client has with the lawyer about the services he's going to perform.
Right. Who else had a hand up here?
I was going to say that.
Federonki?
Yeah, I was going to say the fee
Yeah.
and
Fee and
agreement
the agreement to what?
to the service.
What the lawyer will actually do, right? And so a limited scope retainer, leaving aside the money part for a moment, is I'm just going to do this, right? just gonna do that little bit of it. So it's kind of, it's similar to unbundling in the sense of you're breaking down what's being done, but you're saying, we're gonna have an agreement, you're gonna pay me a little bit of money, but I'm just gonna do this. And you put it in writing, because then your client says, oh, how come you didn't take it to the Court of Appeal? You say, well, excuse me, my limited scope retainer was only for filing the initiating documents, right? How are we doing? Is it 9? Limited scope retainers, right, okay. Mean hand be good. Is this, it's not in your book because it's a 27 decision, right? It's one of those more current decisions. Okay. So, Ontario Court of Appeal expands the liability exposure of a lawyer for an unbundled service and limited scope retainer. So now, where's your liability, right? Here's your limited scope retainer. Here's what you're going to do, and you've agreed to what's going to be paid. And lawyer number 2, so lawyer number 2 is assessing the accounts of lawyer number 1. An assessment of accounts means what? Assessment of accounts. Lawyer number 1 gives the client a bid. And the client says, hang on, that's a bit much. I don't like that. I'm going to hire lawyer number 2 to assess, to review, to vet in front of a, in front of adjudicator, in front of a trier of fact, for the account. And during the process of that, the lawyer number 2 is retained, so number 2 is retained to assess number 1 for a personal injury claim. That's the underlying substantive issue, right? The client brought a claim against lawyer number 2, says he owes a duty of care to advise about the limitation period of an action against lawyer number 1. And the limitation period is 6 years, whatever it is, right? Limitations Act sets it out. And so, of a possible negligence action against lawyer number 1. So you didn't tell me I had a limitation period to sue this guy for negligence when I hired you to do the assessment of his account, right? Okay? Summary judgment motion. Lawyer number 2, so they're asking for summary judgment. Lawyer number 2 did not, the court says, Ontario Court of Appeal, did not have a duty of care for advice regarding negligence, no duty of care, negligence of this guy, of Manuel. He was retained only in relation to assessment of Emmanuel's account, right? So limited scope retainer, the court says, well, you're limited to was the account fair, did he charge too much, and so forth, not on that secondary issue, okay? And this was the reason. The Court of Appeal overturned the summary judgment motion, should proceed to trial, should examine all of the evidence. Some questions, the point of having a clearly defined retainer, if the courts can find the duty of care of the client to extend beyond that. At the very least, advised clients need to get advice elsewhere if you can't assist them. So the takeaway from that case is that any limited scope retainer has to be very clearly spelled out to protect yourself from the client who says, oh yeah, assessment, but what about the limitation period?
I just wanted to mention something.
Yeah.
It was very gratifying to know that the courts could be just like any normal person, normal lawyer. They didn't read the retainer. I mean, that's the contract. How are you going to come up with something without
Right?
looking at the retainer? That's,
Right?
for me, it's amazing.
Basic. Basic, right? Okay, why don't we take a break, because I think we've got, why don't we take a break? Yeah. Let's take a break, and because we're all here, and then we come back, we'll deal with November 12th, okay? Thank you. Break. Yeah, in the terms of the
Let's go.
Trying to see if I missed anything. A couple of
So-
minutes that I was.
Your case was not very last. That was your case. Case reference was me. And on the code section, that series of self-promotion.
Oh, this is the advertisement.
This is the, any Greenspan.
Yeah, Greenspan, yeah.
That case. I wasn't sure.
Oh,
We were
okay.
last days, we were all like in a terrible room and everything.
Okay.
Volunteer to read some true cross-examination questions. True. They're on the internet, so how true is that? Volunteer. Come on, up here. Okay, so it's this page and then just stop here. See that dot? Just stop there. Okay, and it's lawyer question, witness answer. So this is cross-examination, nice and loud. Say who's talking and they're,
Okay.
ready? Go.
Question by lawyer. What gear were you in at the moment of the impact? Witness, Gucci, sweats and Reebok. Lawyer. That this might need here.
Okay, just a minute. Need to pause.
Okay, sorry.
Did you get it? Yeah. Louder.
Lawyer, what gear were you in at the moment of the impact? Witness, Gucci sweats and Reebok.
Okay, good, nice and loud. Okay, next one, that's one example. True cross-examination, go.
Lawyer, this myasthenia gravis, does it affect your memory at all? Witness, yes. Lawyer, and in what ways does it affect your memory? Witness, I forget. Lawyer, you forget. Can you give us an example of something that you have forgotten? Lawyer asks, how old is your son?
Okay, gonna pause there, right? Can you give us an example of something you forgot? Right? Yeah, okay. Okay,
Okay.
they're all different.
Okay. Lawyer, how old is your son? The one living with you. Witness, 38 or 35, I can't remember which. Lawyer, how long has he lived with you? Witness, 45 years.
There, good. Pause, gives them a chance. Okay, okay. Timing.
Lawyer, what was the first thing your husband said to you when he woke up that morning? Witness, he said, where I am, Kathy. Lawyer, and why did that upset you? Witness, my name is Suzanne. Lawyer, did you blow your horn or anything? Witness, after the incident? Lawyer, before the accident? Witness, sure, I played for 10 years and I even went to school for it.
Blow your horn. Yeah.
The lawyer, what happened then? Witness, he told me, he says, I have to kill you because you can identify me. Lawyer, did he kill you? Witness, no. Lawyer, now sir, I am sure you are an intelligent and honest man. Witness, thank you. If I weren't under oath, I'd return the compliment.
Oh my God.
Lawyer, I'll show you Exhibit 3 and ask you if you recognize that picture. Witness, that's me. Lawyer, were you present when that picture was taken?
Are you serious?
Lawyer, were you present in court this morning when you were sworn in?
Last one.
Lawyer, do you know how far pregnant you are now? Witness, I'll be 3 months on November 8th. Lawyer, apparently then the date of conception was August 8th. Witness, yes. Lawyer, what were you doing at that time?
Thank you. It's timing. Timing is so important. You have to begin and they get the joke. Okay, so that's our joke for today. Okay, I think everyone's back. Let's do this thing. So November 12th, we discussed this once earlier in class, there were way too many of you, trust fund babies, way too many of you to do the presentation for the whole class in 2 hours. Like it just, like the math does not work. So we need 2 sessions. And I've checked with administration. We can have, it won't be this room, it's that our first room, like the original room. For the rest of the classes, we're back in 1006. So it's that room. But I need, and they'll give me 4 hours, like 2 and 2. So I need to know, and I would like to do that. Or we can have a different day, so 2 hours that day and then 2 hours a different day. I would like to do 4 hours, that's me, but each of you would only do 2. Is there anyone that cannot, like everyone's gonna be there for the first 2 hours, like that you're just scheduled, right? Is there anyone that cannot do a second, so you'll do one or the other, but is there anyone that has to do this one because you got something at 10:30? Is there anyone that is completely blocked off? Nobody. So if I put you into 2 groups, the first group come at the first 2-hour session, you guys stay home over and do something else. When you're done, you go, the second group come at the second 2-hour session, and then everyone's done the same day. So you only come for 1 2-hour session, is the first or second. And if it doesn't make a difference, I'll just divide you up. Just divide it up, nice equal numbers, and that's it. Okay, everybody's okay with that? If anyone has a problem with that, speak now or forever hold your peace. Okay? No one has class or an exam or a sick child. Okay, great. That is excellent. So we are doing 4 hours. Well, you're doing 2 hours. I'm doing 4. 4 hours. Good. Okay. On the 12th. Okay, agreed? So I'm going to tell administration that we voted or whatever, and we're fine. Okay, excellent. Excellent. Good stuff. Let's continue. We were talking about limited scope retainers. Okay. We did this slide, I think. All right. So what is a limited scope retainer? Like, there's the visual, right? It's an agreement to provide limited service. It does not exempt the lawyer from duty to provide competent representations. Just because you're carving out this little bit of the retainer doesn't mean you can slack off. You still have to be competent to do whatever it is you're agreed to do. The rule, 3.2-1A, it's in your code, requires the lawyer to advise the client honestly, candidly, all that good stuff about the nature, extent, scope of the services that can be provided, advise whether they can be provided with the financial means of the client, confirm the services in writing, give a copy to your client, email it, fax it, courier it, laminate it, frame it, give it to your client. This will come back. Your older fellow will thank you for doing that. Make sure it's reduced to writing, and there's an agreement, and an understanding, and you must confirm the services and give the client a copy. It's practical to do so. Find a way. There's your rule reference. And when it's complete, when you finish this little bit of your limited scope, and there's 5 more steps to go, but you're done, then you write a letter when the retainer is complete. I have finished Part A. I will not do C, D, and E. You will find someone else to do C, D, and E, or come and see me again, possibly. It depends if you want to do that and break it up, but you're going to report on that. So the Law Society of Ontario will send you emails into your inbox from time to time, updates about the profession, decisions of not decisions, but policy developments, convocation, and so on. Convocation is like a meeting of the Law Society Ventures. And in January of 2018, so a year and change ago, a year and a half, there was an e-bulletin, and it's just sort of guidance for the profession. Here's some information how to interpret this emerging issue, right? Because there's constantly all kinds of emerging issues coming up. And it talks about retainer agreements and engagement letters, and talks about you should confirm the terms. The essential terms may be confirmed by agreement executed with an engagement letter. This will vary depending on the services, and just guidance for the profession. So that's an example of, a year and a half ago, this issue is being pushed out to the profession in Ontario. So the things to consider in your limited retainer agreement and engagement letter are the scope of the services, what fees will be charged, how communications will happen, and when withdrawal may become an issue, how it will be dealt with. If you choose to use an engagement letter or retainer agreement, it should be clear and explain the terms in plain language. So plain language is an initiative to use less legal jargon, avoid Latin, law Latin, if you're fond of it. And again, you're not your older self, but thank you younger self. So the e-bulletin recommends the use of an agreement or engagement letter documenting the scope and terms of professional relationship is required. So the recommendation of the e-bulletin is guidance, but here are the rules that mandate certain types of communications, okay? So the rules of professional conduct in Ontario have certain rules for contingency fees and referral fees. So notwithstanding the general advice and guidance to say you should have these, in some cases they're very specific, and these are the Ontario rules. The Ontario rules of professional conduct, they're called, modeled on the Federation Law Society's model code.
Sorry.
Adirondack.
What's the main difference between a retainer agreement and an engagement letter?
Well, the retainer agreement tends to be in the nature of a contract. Consideration, you will pay me X dollars, I will provide you certain services. An engagement letter is like a cover letter to say, you've engaged me for these services, I will act for you, I will bill you monthly, that kind of confirming that you've retained the lawyer, and then this will be the nuts and the bolts. And in this case, in this topic, we're talking about a limited scope retainer, right? So you want to make that clear. Yeah. Good. Okay. So access to justice. How do we think broadly about this issue? Let's think about some innovations. Let's think about some new ways to approach the issue. How about multiplicity? Thank you. Montepulciano, I'm thinking of the wine, right? Practices, where you have in one building, right? In one office, you've got legal, social, health. You might have mental health professionals. You might have employment professionals. So you're part of an integrated service that means lawyers can smoothly transfer clients needing counseling to other professionals. There's a solicitor-client privilege issue, which you always have to keep in the back of your mind. But remember earlier today, we were talking about one of the problems, one of the barriers to access to justice was referral fatigue, right? Remember that? Mm-hmm. So this is one way of, you're still referring, but you're saying, I'm going to refer you to Delphina. I know her, I've worked with her for years, she's part of our group, she's next door, as opposed to saying, here's your referral. Take it down to the social services office and good luck to you. Right? So it's that notion of addressing that component of referral fatigue by having everything in-house. Not everything, many services in-house. That's one innovation, right? That's how we're going to try and deal with this access to justice crisis. Yeah. June.
We talked about, was it last week or the week before, about fees and paying non-lawyers.
Yeah.
How would this situation work?
Well, it would depend on how you structure it, first of all. But for example, you could say, I'm not sharing my legal fee with the social worker. That person will have their own fee arrangement. So you could structure it that way. But you're right, you can't share it with a lawyer. You're right. Yeah. Okay, what other innovations, what other good ideas do we have? Increased coordination among various agencies. That's a policy, governmental kind of approach, right? Holistic advocacy promotes broad client-focused services that address underlying problems. Underlying problems in criminal law include poverty, mental illness, alcoholism, abuse, PTSD, family dysfunction. So it's kind of that notion of, like, you've got the criminal problems up here, but what's the root? Like, where does it stem from? Like, what's the source? And if we can address those problems, guess what? The problems won't grow into the broader problem of criminal activity. Contingency fees. Another access to justice approach is to have a contingency fee, which means what? What is a contingency fee? Okay.
I would say based on what you do. So, I think based on what you do. So if I do this, this is not what you do. So the depth of what you do.
Okay. 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 So let's look at. I mean, that's sort of the notion, but let's look at it. Ahmad.
You get the money from the money awarded by the court. So
Yeah. So it's after the fact, right? So you don't pay until. Okay. And let's look at it. Let's look at 3.6-2, and who would like to read that out loud? I think there's some interest going on here. 3 point. Have you got it? Yeah. So read 3.6. And then commentary 1. 3.6-2. You got it? -2. Read that and then commentary 1. Here we go. Stand up. Nice and loud. Nice and loud.
So 3.2-2, subject to...
No, 3.6,
sorry.
Yeah, yeah.
Okay, subject to rule 3.6-1, a lawyer may enter into a written agreement in accordance with governing legislation that provides that the lawyer's fees is contingent in whole or in part on the outcome of the matter for which the lawyer's services are to be provided. Commentary 1. In determining the appropriate percentage or other basis of the contingency fee, a lawyer and a client should consider a number of factors, including the likelihood of success, the nature and complexity of the claim, the expense and risk of pursuing it, the amount of the expected recovery, and who is to receive an award of costs. The lawyer and the client may agree that, in addition to the fee payable under the agreement, any amount arising as a result of an award of cost or costs obtained as a part of the settlement is to be paid to the lawyer, which may require judicial approval under the governing legislation. In such circumstances, a smaller percentage of the award than would otherwise be agreed upon for the contingency fee, after considering all relevant factors, will generally be appropriate. The test is whether the fee in all of the circumstances is fair and reasonable.
Thank you. Okay, so fair and reasonable, right? That's your standard. That's the guiding test. Even though your client may agree, or you may have come to something where it makes sense for the client, it has to be fair and reasonable. It may have to be court approved. So, one area of law that we kind of touched on a little bit is but pretty common to have a contingency fee component or structure. Hold on. Vanessa.
So personal injury law.
Okay.
Yeah, that is area of law that I'm working in right now. So all the lawyers in the industry charge on a contingency basis. And I think this is also it's very relevant to today's topic too. So access to justice. So we know that people who are injured, so either in a premises or anywhere, in a city or in a car accident, they are just normal person, right? They don't have the money to pay lawyers to fight for them. So and their enemy or the defendant would be the insurance company, who are corporations who are rich. They can hire very competent lawyer to defend them. But those injured persons, they don't have the money to do that. And so the whole industry is providing service on a contingency basis.
And if a person is injured, a car accident or in their home, chances are maybe they're not working for a period of time. Yes. They haven't even got an income to run the rest of their lives. Yeah, so that's a very good example. And is it industry-wide? Are there any exceptions that you know of, or it's industry-wide? Industry-wide, okay, on plaintiff side. Yeah. Okay. For example, anything else? Any other examples where a contingency fee payment makes sense?
Debt recovery?
Emmanuel?
Debt recovery.
Debt recovery?
Yeah.
June?
Class action lawsuit, such as other torts, such as manufacturer.
Negligence.
Yeah.
Yeah, exactly. So you can see all of those examples are situations where it's like a logical approach to say, well, let me take it on, and depending on the outcome, we'll have a contingency fee payment. But it has to be fair and reasonable. Okay, good. Okay, there's a maximum percentage that is set, and the courts can review contracts if they are alleged not to be fair and reasonable, and the court will determine whether or not it is. Okay, and then we talked about unrepresented litigants in the past, and this is one of the ways in which, by allowing and providing rules that are helpful to self-reps, unrepresented, same thing, I use self-rep, whatever, same thing. There are rules that guide us when the other side is a self-rep. And 7.2-9 says, when you're dealing for a client or acting for a client, other side is a self-rep, you must urge that person to get legal representation, which kind of always strikes me as a little bit counterintuitive. Like, there's probably some reason why they're a self-rep. I mean, sometimes they think they're just smart and they don't need a lawyer, but sometimes it's a real issue of, right, funding. But you should encourage them to say, things are going to go better for you, be faster and more efficient, and we can sell. Take care that the person does not proceed under the impression that you will be protecting their rights in any way, shape, or form. Make it clear your only duty is to your client and not to them. Model code commentary. If for any reason you decide that you will act for both, there's a joint retainer rule that you have to follow. There are certain rules with joint retainers. 7.2-9, read the commentary. I mean, we're not going to read every single section, but there's your reference. You can go and read it. Third-party litigation funding. This is an interesting thing. So third-party litigation funding is in exchange for providing a financial hedge against, this is another innovation, right? Against expenses. An outside funder may receive 40% of an award depending on the extent of the resources advanced. Proponents say it's a way to increase access to justice, although it's for complex cases. So what this means is that for some reason, Vanessa would like to see a certain outcome. She's not an intervener, but Adirondacke and Chandeep have a litigation going on, and Chandeep needs some funding. So Vanessa, as a third party, will say, I'd like to see this outcome. I'm not an intervener, I'm not a party, but I'm going to fund your plaintiff's action. And I'm like, there are probably a million reasons why a third-party funder would do that, but you got to think, there's something in it, right? Like, there's going to be something going on here. So there's a little trepidation with this notion. Now remember, back in 1305, the Maintenance and Champerty Act said you can't do that very thing. Repealed in 67. That's beside the point. So this is a version of third-party funding. Proponents say, okay, so it's, I don't think it's widespread by any means, but you can see some of the sort of issues. But it's an attempt, right? It's to say this is how we're going to help access to justice by this third-party funding issue. Those wary of these deals raise concerns about whether the client is best served, right? Because don't forget, the third party gets a cut at the end. A few decisions in Canada on this: profiting from someone else's lawsuit versus access to justice. It's just not clear. It's not clear, it's controversial, and not very widespread at all. But there it is, it exists as a notion. McIntyre Estate. Do I have a page reference for you? What slide is that? No. Okay, so no page reference. There's a case that deals with it where the Ontario Court of Appeal cautioned contingency fees should be regulated and controlled and oversight by the courts. Contingency fees, not third party. here's a case where Justice Perel dealt with third-party funding. Also not in your text, so it's an FYI kind of thing.
McIntyre is in our book.
Okay, what page reference have you got? McIntyre Estate?
I think I got it out of the book.
McIntyre Estate,
Yes, McIntyre Estate.
2002. Okay, page reference? Okay, well, it'll be in your index. Okay, it's in your book, it's in your index, I mean, yeah, that's fine, that's great. Thank you for pointing that out. Okay, in this case, I believe it's not in your text, but the Ontario Court, Justice Perel says, while much of third-party funding litigation so far has been in class actions, right? Other forms of commercial litigation are likely to grow. In one case, there's a pharmaceutical company involved, and companies under debtor, creditor have also been just other ways to help gain access to justice in a creative approach. Just an example. International examples, this is FYI, other jurisdictions and how they approach access to justice on a broader scale. And this was a convention conference in 2016 that set out some of the other jurisdictions and countries that deal with access. Does anybody have an example from another jurisdiction that they know of where access to justice is being addressed in any way? Okay. You know, e-justice, access to information, various approaches. Pro bono work. In the best traditions, lawyers helping clients, pro bono work is encouraged. Pro bono work, in Rule 4.1, Commentary 2, says as a matter of access to justice, it's in keeping with the best traditions of the profession to provide pro bono services or waive a fee when there is hardship, poverty, and so on. Law Society encourages you to do so. And they have a subcommittee or a group, a pro bono group, where lawyers come together, they talk about issues, they provide pro bono services. Excuse me. Why should we do that? Well, it's a privilege to be a lawyer, right? You have a monopoly over the law, except for self-reps. You have a monopoly. It excludes others from practicing. We know about self-regulation. We regulate ourselves. We can judge. We sit in judgment of each other. In exchange for this autonomy, this privilege, there should be a corresponding obligation to ensure access. Education of lawyers is subsidized by the state. Is it? Who's subsidized by their parents? Right? Or your spouse, or the banks. Maybe some places. I get, you know what, they're talking about OSAP, right? Which isn't a subsidy if you pay it back. Right? Maybe in some jurisdictions. Okay. Should it be mandatory? Hands up. Pro bono is a good thing. It enhances the profession. It'll enhance your experience. Hands up. Pro bono should be mandatory. No way. Free society, free choice, free professional autonomy should not be mandatory. Okay. It's not. It's not mandatory. But there is some discussion as to whether it should be. Arguments for mandatory are you feel good about doing it, it's the right thing to do, helps the community, helps society, helps the profession. However, how do you impose a system of pro? Although somebody once told me they did have a jurisdiction where it was mandatory. Anybody? Wasn't this close? Spain? Does that sound right? Anybody? So I think in some jurisdictions maybe it is mandatory. X number of hours per year. Ikra.
I think if it was mandatory, it would support or it would counter all the arguments against self-regulation that were not just reviewed by the profession, but the clients.
Right? There's that argument, right? It would reflect better on the profession as a whole. So should it be mandatory? And so one of the things that you'll find is this hotly debated, ongoing debate about whether it should be mandatory. And so you can read it if you want. I don't think we have time to actually read it, but February of 2019, Chief Justice remarks spark a debate over mandatory pro bono for lawyers. And it's just an article that there was a speech by the Chief Justice who said pro bono is a good thing. Let's think of anything mandatory. It provokes this huge debate and ongoing discussion, just like the, remember the soft debate? Lawyers, right? They're the worst. They can argue both sides in it. Okay. So it's like a real world issue, February of this year. Oh, okay. Ooh, okay. Look at that. Look at that. Personal best. Okay, so let's talk. We have a moment. Talk about Howler. So this is the movie, right? Not on your exam. You do not have to watch this movie for the exam.
So what's the name of that movie?
It's called The Lincoln Lawyer. Lincoln as in car, as in car. It sits in the back of the car and bikers drive out and throw money and they laugh. What? You could do that, sure. Maybe in the States. So here are the facts, and so what happens is he represents Roulet, the character who's a serial killer. At least he's accused of being a serial killer, and surprise, surprise, he actually is. He has a prior client who's wrongfully convicted of one of this client's crimes, right? Some of the issues in the movie that they don't like, the movie's not about legal ethics, right? It's about this story, but these are the issues that, for our purposes, are reasonably interesting. Privilege and confidentiality as between this client versus this client. So what Howard does is he tells another former client to tell a jailhouse snitch, that's a legal term, jailhouse snitch, about the wrongful conviction, so it's all like messy. He tells his ex-wife, who's a prosecutor, about the wrongful conviction. Confidentiality issues, maybe? But the information is found by his investigator, to whom he delegates, non-lawyer, right? Who was working on this guy's alibi. And he's an officer of the court, Howler is, but he tells the judge and the jury because of a fictional witness, all kinds of legal issues, ethical issues that arise. I mean, you know what, it's a generally entertaining movie, but it does actually touch on a bunch of legal ethics. Okay. That's it for me. Get out of here. I will stay if you want to ask questions or talk about anything else. I will post a notice that we've decided on this. Should we divide you now? Yeah? Okay. 2, 4, 6, 8, 10, 11, 12, 14, 16, 17, 18, 19, 20? There's not 20. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Someone's missing, right? Should I just do it alphabetically? Do you care?
There was someone sitting here.
Maybe I'll just do it unless anyone objects. Alphabetical is as good as anything else, right? So I'm going to do it alphabetically based on your last name. And just to mix it up, I'm going to have the L through Z go first. There you go, you A's and B's. Okay, that'll work. That'll teach you. So I'll post it. So for the half of the class whose last names are in the, like me, in the lower half, will come at 8:30 on the. I'll put it in the Moodle, or the Moodle notice. 8:30 on the 12th. By 10:30, you're done.